Dear guests, we'll begin our panel and we can start discussing our today's topic. My name is Alexey Kozyakov. I'm a lawyer in St. Petersburg legal chamber. And today's theme are legal mechanism of defense against deliberate bankruptcy. We agree that we'll discuss some of the aspects of this topic, understanding the idea of deliberate bankruptcy in a broad sense, understanding all insolvency procedures that are exist both in Russia and in other jurisdictions. This panel covers two major blocks: the legal practice, the court practice, and the tools of legal defense that exist in Russia that can restore the infringed rights during the insolvency procedures or before. And the second block of ideas that would be interesting to the professionals and to banking circles is the prevention of deliberate bankruptcy by singling out the debtors' features that could show that somebody is going to start the deliberate bankruptcy procedure and their creditors or counteragents should take some steps to prevent damages. We'll start with giving the floor to Mr. Vladimir Slesarev, Deputy Chairman of the Supreme Commercial Court of the Russian Federation, who will speak about the success that we have in Russia regarding going to trial on cases involving deliberate bankruptcy and protecting the creditors' rights. The Institute of Bankruptcy plays two roles. On the one hand, it provides the protection of the interests of creditors, since it creates conditions under which the property that belongs to the debtor is distributed by creditors. On the other hand, the idea, the philosophy of this institute, it limits the debtor's responsibility as well, because for a while the debt is being set and this debtor will not be suspended forever. So these are two plus sides. But in Russia, the specifics of economic relations are such that this institution mostly protects the interests of the creditors, because it seems that the commercial practice, as a result of bankruptcy procedures, the debtors is left with nothing, providing for their future development and so on. It's very hard. I think that here, this is a rather lopsided institution, but at least it provides for the interests of the creditors. What do we need in civil legislation, in bankruptcy legislation, to protect the interests of creditors? First of all, the legislator says if the property of the debtor is not enough, we'll find another source which will help the creditor to receive money, which means subsidiary responsibility of controlling persons. You know that Russian legislation on bankruptcy says that if there is an action aimed at damaging the creditor by the controlling parties, they are subject to subsidiary responsibility. You can't find very much money there, but the threat of the fact that apart from the debtor's property, you can also delve into the property of the controlling entities. This is at least some kind of incentive to make deliberate bankruptcy less attractive and less widespread. Since from the economic point of view, this situation is absolutely irrelevant, we can safely say, I think, that this procedure, this subsidiary responsibility only has some kind of a preventive function. This clause works just as I looked it up. There is court practice where people are brought to criminal responsibility, administrative responsibility, if there are no consequences provided for by the criminal code. When we don't need to be looking for extraordinary sums to compensate the creditor and so on, such clauses can work if if people pay attention to them. They will not be very useful for the creditor, but a certain background will be created so that the debtors wouldn't lose all their property. The role of civil law here is restoring the money to the general monetary circulation, which is artificially taken out from the debtor, and thus reduces the abilities of compensating the creditor. And here, the main thing the function of arbitration courts is to look at the legality of the actions of the transfer of assets from debtor to creditor or vice versa, or from third parties to the debtor, and to check whether there are any actions that are somehow related to bankruptcy, to reducing the creditor's ability to be compensated. The higher arbitration court of the Russian Federation functions as a court most intensively when the presidium assembles about 15 people every Tuesday of every month. 10, 12, 15 cases are reviewed, and at every session of the presidium there are bankruptcy cases, including those that are where the deals have to be considered null and void because they infringe on the creditor's interests. And since there is no definition of such deliberate bankruptcy in civil law, they are connected to the activities that infringe on the creditor's interests. I looked up a lot of material preparing for this panel, but then I put it aside because yesterday we were looking at 3 bankruptcy cases. They are very much within the scope of our discussion, and I'll probably share a couple of interesting comments with you. The first problem I would like to point out: the courts review demands on considering the deals null and void, which consider removal of property on the eve of bankruptcy or during the bankruptcy procedures. What are the problems? The first problem is purely legal. It's not connected to any kind of proof or evidence, because the Presidium of the Higher Arbitration Court shouldn't be looking at the evidence, because in that case it would not be fulfilling its mission. If we had 150 or 1,000 or 1,500 people, then we could probably look at all the evidence. But right now we can only look at the application of law, certain uncertainties or differences in the application of law. And one of the problems we encountered is connected to the applicability of the norms of the deals that are invalid, which are listed in the bankruptcy law, but not in the legal code of the Russian Federation. So special and general legislation as regards the invalidity of the deals. We have a decree of the session of the Higher Arbitration Court, which solves these issues in the very general form. Point 4 and point 10 of this decree on certain issues related to invalid deals says that the bankruptcy laws have special stipulations which do not prevent the court from considering such deals as invalid. This is said. This is written in the legal code. What's the difference? How we qualify this deal? We can point a cat any color. The important thing for the cat is to catch mice. But a black and a gray mice catch mice in different manner. So depending on how we qualify this or how we define this deal, sometimes we are able to protect the creditor's interests and sometimes we're not. One of the things here that is decisive is the difference. The difference mostly is this: to the bankruptcy laws consider the deals that can be disputed, and this is regarding invalid deals. This is a principal difference. Speaking of the practical side of the question, essentially on the surface, and this is very important because what is on the surface is quite often the most important thing for the practice. What we have on the surface, the main difference is that the statute of limitation are different. 1 year or 3 years. If we qualify, if we define these things as 10.168, we can be solving these issues during 3 years period. If we take the bankruptcy law as our guidance, it will be a disputable deal with 1 year statute of limitations. If we're outside this term, we will be denied our demands regardless of whether there are any material justification for considering a deal like that void. I quoted from this decree the existence of special deliberations does not preclude the application of general rules. But it's very difficult because the more abstract the rules, the more difficult it is to apply them to specific cases. Here's the thing. This case was reviewed by the arbitration court of the Krasnodar Krai, then appealed, then reappealed, and finally it came down to us. Also regarding the statute of limitations. What is the substance? An open joint stock society, Rosselschossbank, from the debtors took the debt from the debtors' corresponding account. Doesn't matter why. The expenses were related to crediting the account of the client of that bank. And the expenses were taken in advance before the bankruptcy, and the bank knew that it won't have enough money for everyone. So it satisfied all its requirements on a non-accept basis, leaving all potential creditors without any compensation, without any money, or at least without that sum. That was ascertained, and the dispute between the first, second, and third instances, it was connected only with the application of this point from the plenum's decree. Was the bankruptcy procedure already launched? No, it was before that, on the eve of the bankruptcy.
And it was found out, it was to qualify these actions of the bank as regular in a situation when the bank was fully aware of all the transactions. The bank was fully aware of the situation. And the court, court of the first instance and the second instance were very different in their opinions. The first instance and appeal court considered that the bank took the money deliberately to cause damages to the creditor and the future creditors. And based on the 10th article of the Civil Code of the Russian Federation, not the bank, but its manager, based on the 10th article of the Civil Code, the bank has committed, according to the 161st article, acted illegally. Appeal court had a different opinion. They said, we have a special norm, provisions in our law. We have a bankruptcy law that provides for the same activity, illegal activity, as activity that has to do with writing off money, that you can't make preferences. So this action was illegal according to the bankruptcy law. Therefore, one shouldn't use general provisions for considering deals void, null and void, but we should apply bankruptcy law and see these actions, if not void, then disputable. And if you can void it, then see what the term of limitation is. It turned out that limitation term was written off, and they had 1 year limitation period. And yesterday, on Tuesday, we had a very long discussion about what should be applied, what kind of legislation should be applied here. Because this plenary session decree that I mentioned, it doesn't explain it. It says that you can apply specific provisions apart from the general provisions, but only in case if this breach of legislation is specifically provided for in the bankruptcy law. If there hasn't been any specific breach, we could have applied it because it's a different kind of breach. We've been thinking, well, 3 judges that could not decide, I mean, that were uncertain on the balance between general and special provisions. And other 3 judges said that there were no grounds to apply the 10th article of the Civil Code because these actions were in breach of the bankruptcy law. And the term would be 1 year to reapply. And finally, Presidium of the highest arbitration court made a decision based on the following. I'll try to read it. A violation of when the creditor received the money from the debtor in a situation when the creditor knew that his debtor was in default, was insolvent, breaches the subsequent provisions of the bankruptcy law. These actions cannot be declared void. I don't think we'll keep this wording in the final decision because we'll have to work on it. But it is not. It doesn't mean anything really. These actions cannot be declared void because they can be voided. They're voidable. If we when we say that it is not void because they're not voidable, it's the causal link is missing. I think we'll rewrite this decision. But once considering the balance between general and special provisions for void deals, the decision reads, we're talking about flawed deals that go beyond suspicious deals. We'll have to apply the bankruptcy legislation. Whatever the manager said about the voidability of the deal were aimed at breaching the terms, which is not permissible. In other words, the idea of this provision is that if we take some special deals according to the if we take deals with preference, these deals can be viewed according to the 10th article of the Civil Code. But in this case, they should not be mentioned in the bankruptcy law as a basis for a special way of solving this this matter. So we thought that the legislator tried to remove these matters from the 10th article of the Civil Code, attaching to it a special norm. The legislator has excluded a possibility to move these kinds of deals under the general provisions. So this is a kind of a general provision that would allow us to solve the matter, since the deal was considered voidable. The demands of the defendant could not have been satisfied. Well, we have the following situation. If we cannot reverse it, we have a discussion for any document. So we don't have the final document. It doesn't have, it's not retroactive. And we only have the results yet of this whole story. There are a lot of issues that have to do with well, this yesterday's case. We viewed a situation when property should have been sold at a certain price within the certain time frame to get back the money. Well, about 20 or 30 million rubles worth of property. And they got back only 800,000 to their account, and the rest of the money was received in the form of promissory notes. It's obvious what were the causes for these decisions. They had this agreement. The parties came to this agreement. We had some other cases, but each specific case has its own peculiar features. But this first case, which included some actions that can be viewed under the special and the general provisions, it shows that we have to treat each case separately, and we don't have any general framework for this kind of a problem. The competition of norms, the general and the special norms. There's a very close topic linked to this issue, the competition of procedures. When we void the deals, we can apply different articles of different codes. We remember when bankruptcy law legislation was reformed, there was the special 3.1 article that all deals voidable or whatever other deals should be reviewed under the provisions of the general bankruptcy provisions, bankruptcy law provisions. They would when this part of legislation was discussed, they thought of eliminating a whole number of articles. But if we look at our arbitration courts today, you still have this competition of two proceedings. And a lot of deals are reviewed under general provisions with references to the 10th article and general rules for the terms of limitation. Well, the issue of competition is very complex. There's a point of view. I'm not even talking about the competition of provisions, because you have competition between the contract law and reimbursement. We the legal scientists think that there should not be law on competition, for example, and I'm ready to agree when we talk about the bankruptcy legislation. Special provisions that make it possible to solve these issues, to resolve these issues in a complex way. We're not talking about legal competition. We're stepping back from the bankruptcy procedure that we already have provided for. Our next speaker is Konstantin Kolpakov, Vice President of the Uralsib Bank. He would probably talk about it from another viewpoint, from the point of view of those who would write off their money in a non-acceptance mode. Maybe you should have been more careful with our reputation. Good afternoon, dear colleagues. I'll start in an old-fashioned way. I was educated in the Soviet times, and I had my postgraduate degree in Tomsk, in the Tomsk State University. Well, I should say that the topic is very relevant. It's very hot. In everyday life, as a bank collectors see it as very relevant for strategies like restructurization. There's little place left for restructuring, but there's a lot of space for bankruptcy. If we read about things that are happening in the global economy, we can feel, we can sense that it's going to be very topical, especially deliberate bankruptcy. To put it mildly, well, a lot of legal or quasi-legal practitioners has no limits. They often go beyond existing legislation. When you look at what people are doing, you get shocked, and people's creativity in this area seems to be unbounded. In the law number 127, there's no idea of deliberate bankruptcy. It is only covered by criminal code. There's a very thin line between civil and criminal legislation. This is my own opinion. You may argue, but our criminal legislation is of very chaotic nature now. I mean, its development is very chaotic. But let's put it aside. I would like to emphasize that there's no notion of deliberate bankruptcy. We're not, going into academic dispute here. But once the law does not give a proper definition, it's very bad. Not only because we do not explain how we're going to punish for this, but we don't have the final provision. How do we do that? The first and the easiest way is to avoid the deal. Existing bankruptcy law says that the appeal that the suit can be issued by the creditor and no one else. if I were a judge, I would think this is a very proper procedure. We meet here every day. I've been taking part in this forum every year. You would know we can use it very different ways. If we look at the procedure from another side, or you can use the same tool in a reverse way. The process of making the deal void. We understand that before bankruptcy, debtors may conclude certain deals that would be void deals, and that would work to remove certain assets before bankruptcy. As for the banking management, it's easy to see if the financial situation of someone who takes a loan from a bank is deteriorating. If you take a closer look, if you monitor what is going on, the level of assets, their own loaned money, you will see that someone is doing worse and they're trying to remove their assets. What is difficult is to understand whether it's done deliberately or non-deliberately, or whether they're doing it to save their business or to start a deliberate procedure, deliberate bankruptcy. When we're talking about a production facility and their assets, it would be most relevant for us dealing with these matters. It would be necessary to give an opportunity to those interested to dispute, to challenge these deals, and to challenge these actions. Whether these deals, these promissory note deals, are challengeable would be very, very important. Quite often, this kind of debt would be ground for the deliberate bankruptcy.
Либо можно...
Since challenging a promissory note transaction is extremely difficult, and honestly, I don't think many people have learned to do it, and since there's quite a few cases like that, this is a fairly justified conclusion. Next, let me say that identifying premeditated bankruptcies is the role of arbitration managers, because arbitration managers are supposed to identify if the bankruptcy is real or fictitious. There's a decree, the temporary rules for signs of fictitious bankruptcy. According to these rules, the arbitration manager is supposed to check the activities for the at least last 2 years and for the entire period of the procedure, and that's a classic 2. They're supposed to check all the accounting reports, documentation for the acquisition and disposal of assets, tax audits, and if it's found that management led it to the bankruptcy in a way that is premeditated, then they have to report to the law enforcement authorities. But honestly, since the responsibility for a incorrect execution of the documents, and if this is not in the text, then I will not dare to say that this is an effective institute. There's another problem. The arbitration manager receives incorrect information himself, or he's not provided the necessary material. How do you fight this? I think the easiest is to have liability established for the owners, for the managers who conceal the information or destroy or falsify documentation. The state agencies involved, a lot can be said, but there's no impression left that the bankruptcy issue, even though you should agree that in the last, so to say, some 10 years, the improvement of legislation, if you take some of specific examples and the frequency that this is raised, I don't think you'll see a lot of topics that for the legislator to take upon as often as that. And this is about bankruptcy in general, financial institutions, bankruptcy. Something is changed all the time, but honestly, there's the understanding that bankruptcy, especially in these uneasy financial conditions and cyclical crises, people are becoming aware, and the government is understanding that this is a critical procedure that requires not just clear regulation, but there should not be too much bells and whistles about this, because today's impression is that bankruptcy is a extremely relevant issue today. But when you go to the law enforcement agencies, to the Federal Registration Chamber, the emergence of this term, the term of bankruptcy, is already a matter of concern. It's got to work effectively because most importantly, this is aimed at having some order in the economy. I don't have that impression. How do you get there? I don't know, honestly. All I know is that there are some tested, proven methods in history when the state, the government, does it by way of a consistent sequence of steps. And when the ideology or the philosophy becomes a practical task to perform. I don't think we should spend too much time on ideology, though. But as regards premeditated bankruptcy and bankruptcy in general, this should become a matter for the entire state to address. Well, my time is running out, so just a couple of words. The bankruptcy procedure, in addition to the above premeditated bankruptcy issue, is that the material law itself is imperfect. We've been talking about this for many years, that the periods of limitation for bankruptcy that exist are bad. They do not help the efficiency, the effectiveness of the process. But still, the procedure is long and drags on and on forever. Now, we've been talking a lot about the declaratory nature of mechanism for the restoration of the solvency of the debtor as financial healthy procedures, and this procedure has works only from time after time, and then there are issues about the faithfulness about the parties, lack of responsibility, this joint responsibility, other types of responsibility stipulated by the law, but still they have a role of prophylactics, prevention. And let me now note the Supreme Arbitrage Court and the recent positive attempts to establish a right practice as regards initiating cases for illegal actions. They have introduced some good rule of law in this area. But this nature of prevention that we have in the law today, unfortunately, still remain prophylactics. And I'm not insinuating that we got to have some long terms, that we should have some loud cases in terms of the economic climate would give everybody to understand that this is important for the economic rule of law. Unfortunately, there's lacking, and we got to move from these prophylactics to more substantial sanctions. This is about it. I could continue talking, but we have here more colleagues, so if you have any questions, I'd be ready to take them offline. Thanks. Thank you. We're now moving to our next second section about international cooperation in bankruptcy matters, transnational bankruptcy, and the relevance of related issues is well known. We've been seeing this in Russia for 10 years, where corporations are building holding companies located outside the country of other jurisdictions. So one way or another, we face either several bankruptcy procedures in Russia and concurrently in other jurisdictions, and the right to withdraw assets from the country. So as Konstantin has noted, until you leave your workplace, you got to take something with you. Well, we need mechanisms, toolkits to fight this way of avoiding responsibility. We have three speakers, three panelists. Let me introduce them. They're experts from different jurisdictions, leading representatives of the lawyer community from the U.S., Brazil. They have successful experience in both jurisdictions, and they can tell us a lot of interesting as regards international security. Edward Davis Jr., one of the lead experts in the U.S. on bankruptcy procedures. Alfonso Enrique Alves Braga, a lawyer from São Paulo, Brazil. He is one who's a practitioner and knows this very well, and an interesting guest, a liquidator, Rodrigo Kaiserlin, who works with major companies in Brazil and transnationals. So our colleagues have the floor now.
Alexey, first, thank you, and also Vasily and the organizers for inviting let me turn this on, me to speak here. I very much appreciate it. It's my first time in Russia, and I'm very excited to be here. According to the cab driver and the bus driver, I'm seeing the very best part of Russia right now, so I don't need to go anywhere else. I'm sure there's a difference of opinion in the room on that. I actually have a short PowerPoint that I want to use to accompany us. And I think that it was really interesting to hear the judge speak about the ideology, because ideology, I think, is important. And I just want to give you 2 minutes on the ideology of the U.S. bankruptcy system. First, it's to fairly and equitably distribute assets to creditors. And I've spent 27 years representing creditors like Constantine, bankers. In the United States, we refer to those departments as the Special Assets Department. And I don't know if that translates well in Russian, but Special Assets Department is SAD, which in English spells sad. So we refer to that as the sad part of the bank. Our job as lawyers, as creditors' rights lawyers, is to make the sad part of the bank happy. Sometimes we do that. Sometimes we make them cry. So we do our best to make them happy. So first, we look to distribute assets to creditors. Secondly, the bankruptcy code is written in a way and has been interpreted in a way to sanction debtor fraud and misconduct. That's very important because one of the main thesis of this panel is how do we discourage deliberate bankruptcy, which I would refer to in the US as tactical bankruptcy, not deliberate bankruptcy, because all of our bankruptcies in the United States are deliberate except for what we call involuntary bankruptcies, and those are pursued by the creditors. So tactical, and I'll come back to that in just a second. And then lastly, this to provide the debtor with a fresh start. Now this is an interesting difference in our system from a lot of systems. In most of the systems we deal with in the Caribbean and Latin America, for example, which are civil law systems or Old English common law systems, the bankruptcy vehicle is the vehicle you use to take the body to the graveyard. It's just to drive the body there. It's always going to the graveyard. There's no other way to go. There's no other stop. Slowly, we're seeing the law change to allow reorganizations. But also, companies need that fresh start sometimes. Individuals, we want individuals, our economy is primarily predicated on innovation and risk-taking. So we encourage people to take the risks, and if they fail, legitimately fail, we then give them a chance by cutting off the debt that they incurred as part of their innovation and going forward. And there are thousands of stories of billionaires who've started out in their first 5 companies, fail, and then they have the 6th company and they do very well and employ thousands and thousands of people. That obviously, so we unlock that energy with this concept. We unlock that, but we also unlock the chance for abuse and the opportunity for abuse. And we do have it. We cannot deny that we have the opportunity for abuse, but allowing people to start over when they're in business is an important philosophical part of our bankruptcy code. And frankly, when it's not abused and it's legitimate, and there's legitimate incurrence of debt, and there's legitimate attempt to make new value and to start a new company, and it just doesn't work out. And we saw this a lot in the dot-com boom. Probably maybe 8% of the dot-coms survived, and many of them went into bankruptcy. The 8 that survived, we talk about them every day. They're huge international companies that employ thousands and thousands of people. So it is important to keep in mind the philosophical reason for each of the insolvency systems. So the issue here really is one of forum shopping, and that is do debtors forum shop inside the United States? And we have I see some familiar faces from the insolvency world of the United States, Chris Redmond back there. This is not really that much of a problem. We do have debtors who go to different states and different federal districts to file, like in Delaware, because they presume that Delaware is more friendly to debtors, especially large corporate debtors. Like, for example, American Airlines filed a tactical insolvency because they wanted to cut off heritage obligations, that is, pensions and health care. My own father was a steel worker for 35 years for Bethlehem Steel, okay? And his company went into bankruptcy after he was retired. So my father is a steel worker. His neck is like this, he has huge arms. And I had to sit down with my father and explain the philosophy behind why he was going to lose his pension and lose his health care, okay? Imagine that conversation. It was a difficult conversation. I was, sweating as I was telling my father the philosophy behind the bankruptcy. Obviously, the big government stepped in and took care of his pension and took care of his health care. That was good that the government took care of that, but the philosophy there can also cause a lot of pain and a lot of problems for individuals and sort of the little guy in the process. So we have to always keep that in mind. And I think sometimes our bankruptcy code in the United States is maybe too debtor specific and too debtor helpful, when especially in the corporate milieu that you were talking about. Can a debtor divert assets and transfer assets? Absolutely, they can. But, and they can lie in their court filings. But we have very powerful tools to avoid transfers. So it isn't as much about stopping them to go into bankruptcy. Frankly, in the United States, when debtors go into bankruptcy as a creditor's rights lawyer, I'm very happy about it. It's very helpful. I have more tools to work with as a creditor working with the trustee than I do outside of bankruptcy. And if you lie in bankruptcy, it's a federal crime. And Chris knows about a case that we worked on out of Florida where the mafia took a trucking company and took all of the assets out of the trucking company and then declared bankruptcy. The principal of that company went to jail for 26 years for the bankruptcy crimes that he committed. So it's a serious offense in the United States, and it can really result in serious criminal problems. So it's not as if you have the right to do anything or say anything. I think there's a perception outside of the United States that it's sort of cowboys and they can say anything and do anything. It's not true at all. Our judges are very, very tough judges when it comes to lying or filing false documents. So we do have what's called a bad faith bankruptcy, a bad faith filing. Frankly, they're rare today because in the 1970s, we had a real estate crash. Typical bad faith filing is you represent a creditor and you're chasing them and they have one asset, a big building they're developing. And at the last minute, right before you're about to take the asset, they file for bankruptcy. That's a tactical or deliberate bankruptcy. In our system, the courts have determined that since there's nothing for the bankruptcy court to do or to reorganize, they dismiss them. So it's very rare today to see these bad faith filings because the law has developed such that they've cured this issue to a large part. So most of the time when you see debtors jumping into bankruptcy at the last minute, they're getting very bad legal advice. And so we are very happy because they're in bankruptcy and we have many more tools to use against them. And the court can impose penalties, as I've already said. So what happens now the people who left the room right before this part of the panel started are at a distinct disadvantage to everybody that's in the room right now. Because what we're going to talk about next is a procedure, really an invention, if you will, from my colleagues, to track and repatriate assets that are taken outside of your country. So you have to think about whether this will work for Russia or for any of the other countries that you represent here. But I will say that the presumption in a lot of people's minds, and I could see it even in faces here, is that once assets go offshore, it's over. Well, since we're in the middle of the World Cup, I'll use a soccer or football analogy. It's not even halftime. The game hasn't even started, okay? You can trace and trap assets offshore. If you're not going after assets that are moved offshore, you're really underserving your client. You're underserving the estate. You're underserving the court system. Because you can go offshore. The mechanisms exist. It's just that you may not have been exposed to it in the past. Does it work every time? No. But it's better than allowing a debtor, and this happens over and over again, where a debtor takes a company, moves assets outside of the country, takes the shell of the company, puts it into bankruptcy, and says, I want to be absolved of all of my debt. Meanwhile, the assets are offshore through offshore entities, and they're living a very, very nice life. That does not have to happen. That can be taken away from them. And what I want to do is introduce my colleagues, Rodrigo Caserli, and we have had really the honor and the privilege of working with him and Afonso Braga on large cases out of Brazil. And this procedure, this process that we've developed, which involves going to various offshore jurisdictions. And offshore, let's be very clear about that, means any place that you're not. So if you're Russian, offshore could be Cyprus, Miami, it could be England. Offshore, don't think of offshore as just Cyprus or as some place where you think that people typically take their assets. Offshore is anything outside of your national jurisdiction. So you have to stop and think about is, how can I access those assets that are taken offshore? Because on an international level, we now have a model law. I don't believe Russia is a signatory. I checked before I left. I don't believe Russia has yet adopted the model law on international or cross-border insolvencies. But it doesn't matter, actually, because many countries will honor a request from a foreign bankruptcy trustee to come into their country and assist them. with the possible exception of the Swiss, who, and others who think like them, which say, look, I'm happy to help you, but first I have to make sure that all the Swiss creditors are taken care of. Then, if there's anything left over, I'll talk to you. That's a parochial view, a view that looks internal, and really the view that's starting to spread around the world is more of a universalist view, as you have these multinational companies, companies that have revenues, annual revenues that are larger than many countries. If you stop and think about a country like Nigeria, which is the 49th largest economy in the world, there are 7 US companies alone that have higher revenues than Nigeria's general GDP, gross domestic product, annually. 7 companies. This is just US companies, public US companies. Think about the economic power that comes with that kind of revenue. They have their own fleet of ships, their own air forces, many times a bigger air force than a government does. So you have to level the playing field, and this universalist approach under the ancestral model law and this philosophy allows you as a bankruptcy practitioner, wherever you are, to go to a foreign place and ask for assistance. So I'm going to turn it over to Rodrigo, who can tell you about our experiences, but this team that Rodrigo leads out of Brazil has now frozen almost $1.5 billion in assets around the world in 3 of the largest, most high-profile cases in Brazil, including the largest bank failure in the history of Brazil. They've frozen assets all over the world. So, Rodrigo?
Thank you very much, Ed, for your words. But I gotta tell you that the heavy lift of the work Ed has done in Miami for me, so he's the head of the team, per se. Thank you, Vasily. Thank you, Alexey, for inviting me for the panel. I would like to share with you today a little bit of our experience in Brazil that is being a good one. Bankruptcy, it is a very good tool for the creditors, mainly when there is a bad faith bankruptcy or a diversion of assets. Brazilian law is very strong about getting the people that divert money from the company responsible for the debt. We can pierce the corporate veil if you can prove that the controlling mind abused the company. You can make third parties liable, not only for the amount that they stole for the company, but if you prove that they have patrimonial confusion, you can make this third party liable for the whole debt of this entity. This is a very strong decision out of Brazil, was confirmed in 2011. But this is not enough. Nowadays, it doesn't matter if you have in your onshore, in your jurisdiction, a very strong tools, if you cannot grab the assets. Nowadays, the assets, they are offshore, or they are even onshore, but controlled by offshore entities in a very complex structure. I would like to apologize for Judge Brooks and Chris Redmond because we were together in the last panel, and I'm going to repeat an example that I used that I think fits very well here as well. We worked together in a bankruptcy, in a bank bankruptcy in Brazil, around $2 billion debt, and by the same time the bank went down, a Brazilian company controlled by offshore company, owned by the wife of the controlling mind of the bank, was receiving around $500 million from offshore. Well, we have the symptoms of the diversion of money, but in Brazil, we just couldn't get the evidence to prove the patrimonial confusion. So what we did is we approached the judge, we show him the evidence that bank is going down, this company is going up, where is this money coming from? We file for investigation under secrecy ex parte, meaning nobody other than the judge, the trustee, and the public attorney's office knew about it. We asked for bank records in Brazil. We saw where the money went. The money went for an Uruguayan company who had an account in Miami. We filed a Chapter 15, which is a ancestral model law adopted in Miami. Ed did that for us. We had filed a Chapter 15 in Miami, and then he had access on the account in Miami, and then we found out that this money went to another account, and this account was held by an offshore entity that was the controlling structure of the Brazilian company. And that entity was sending money to Brazil. The same money that left the bank was coming back to Brazil to increase capital in the company and build houses. Only the house of this banker is worth 400 million reais. So that was a case of success that we did together. And I think when you talk about bankruptcy, Ed pointed out very well that the main goal for bankruptcy is to pay the creditors. You bring back the money. And sometimes you see people putting too much effort on the criminal side, which is important as well, but it's much more important to freeze the money, to bring back the money, and pay the creditors. So that's my contribution for today. If anybody has any questions, I'll be glad to answer later or at the end of this panel. Thank you. Back to you.
Good afternoon.
Okay.
Good afternoon. Excuse me for reading, but since English is not my birth language, I think it will be easier this way. I will sharing with you some appointments of my experience of attorney and trustee in Brazil, or our bankruptcy procedures, and the mechanisms to prevent fraud against creditors and will defending their rights. I above mentioned, I am a trustee of some bankruptcy Brazilian companies, as well some companies reorganization. As determined in Brazilian law, I've been nominated by judges responsible to these procedures over the last 15 years. We develop our work as trustee over the last 15 years, nominated by the São Paulo courts. It's secure to say that certain pairings that I would classify as red flags, which, when not are almost always indication of fraud, and therefore suggest a more cautioned analysis. Some typical indications are no accounting records for this maneuver to reading fraudulent mechanisms, debts beyond incomes, suspicious sales, direct bond to offshore companies in tax havens, among others. In my experience, on think the catch the eye is very rich owners from poorly conditioned companies. This is one of the biggest evidence of fraud bankruptcies. For instance, is one these cases in Brazil. The red flags were shown by a number of the people and enterprises constantly bonded in the shareholding and the financial maneuvers between them. Those commercial relationships create with the single goals of the diverting assets from the poor conditioned company, where constantly is a short period of time, and the assets were transferred to all the same third parties. First, the state asked the judge to lift the corporate veil so that the personal assets of shareholders would be reached. This means over 300 enterprises that belong of the economical group, as well as 7 strongmen that were used as one of them. This procedure, listening the corporate veil, made it possible to gather the assets of their shareholders and float them, and utterly to pay the debts before the original company's creditors, who have extended the effects of the bankruptcy those involved in this scheme. To assure this request, we took investigation over several countries, tax havens, and foreign jurisdictions such as the Cayman Islands, British Virgin Islands, Belize, Puerto Rico, and USA, in the hopes of discovery who are the beneficial owners of those companies, as well as asset recovery located in such places. We were also able to, under the U.S. Chapter 15, to promote auxiliary procedure will make our work a lot easier. As we have said, about 300 enterprises were found on the oil industry, propane, sugar and ethanol plant, logistic and tourism agents, constructions, and others. As for the present moment, the main producer has over 190,000 pages, 3,500 file claims, and a debt over $600 million. We are able to find just over $200,000 million over several countries. This indicates to the most of the scams involve the different jurisdictions, making the indispensable the reciprocity between nations. Brazil's legal system will be much more improved when we adopt ancestral model law. Therefore, it's important that the creditors keep watching closely how the company is being managed, allowing to act advanced. Actually, several companies are currently analyzing their debtors, and in case of the insolvency, are searching of their credits directly on the country they can be found, but knowing they won't get anything in Brazil. Is that all? Thank you. Спасибо.
If I can add to that, on the U.S. side of the, actually, if you can go back to that PowerPoint, let me just, I don't know if you can go back to it. On the U.S. side, we first filed a proceeding in Miami called and I want you to, if you forget everything else that I've said, remember this. Remember this one thing. There is a federal statute in the United States called 28 U.S. Code 1782. It allows you, as a foreign individual or company to come to the United States if you have an action pending or you are about to file an action and you need evidence from the United States. Any kind of evidence. You file a simple petition in federal court. The judge issues an order giving you authority to issue subpoenas, and you can serve subpoenas on banks, you can serve subpoenas on law firms and on other entities that are involved. Our first piece for Alfonso in that case was to serve this 1782 on various bank accounts and then on a law firm. We found that this entire legal structure, or a good part of it, was designed by a lawyer in Miami. And interestingly, when the judge in Brazil said, I believe there was a bank accused of assisting the robbing or looting of the assets out of the company. When the judge in Brazil said, okay, I believe you are the beneficial owner of this company. And the person who was the beneficial owner said, oh no, I'm not at all. But they knew that we were going to Cayman to get this information. So this lawyer in Miami, we contend, flew to Brazil. We have his record showing he went to Brazil the day after the order was entered. We show that he admits that he met with the client and read the order. And then his office proceeds to set up 2 new companies in Costa Rica. One is owned by a woman who owns a laundromat that does laundry, and one is owned by an engineer. And these 2 companies are inserted in the middle between the bottom of the beneficial owner and the top company, and this ultimately we were able to show was done by the people who were working for this person. So imagine the power of that, going back to Brazil and showing the judge, not only were they committing a crime against the estate, but they were lying to you as a judge. Imagine the power of that, how much that would irritate a judge. So that, and then we ultimately used that to file a Chapter 15. So those of you that are sitting here saying, well, my country doesn't have insolvent or the model law, so this is not applicable to me. I don't know if you heard, Brazil does not have the model law, and they do this. So these tools are available to you to use as long as your proceeding that you have is what's called a collective proceeding, and I don't want to bore you with the details of what it takes to file a Chapter 15. It's very, very low. There's a very low burden to file a Chapter 15. It's very easy to do. There's a very small filing fee, and you have to allege that you have a proceeding in the in the foreign country that is a bankruptcy proceeding, essentially. And that's the predicate. And what you get for that is the ability to come to the United States. You have an effective means throughout the entire United States, because a bankruptcy court's jurisdiction goes from Miami to Seattle, from New Mexico to Maine, all the way across the whole country. It's nationwide. So you have the ability to go anywhere in the United States once you file a Chapter 15 and serve subpoenas. And we serve them routinely in New York, Colorado, and other places from the Miami court. There has to be connection to some place in the United States. You can't just come to the United States and say, I would like to file a bankruptcy. There has to be some asset in the United States, either a bank account or a claim or other assets that were there, some tie that you can show to your insolvency. One of the things that I think we miss that is really, really powerful about international insolvency is that you are a trustee. Right now, Alfonso Braga is the trustee in Miami. Even though he's not a Miami lawyer, he's not admitted to practice in Miami, he is recognized by the court as the official office holder of the insolvency of this company. So he has standing, he has official capacity and power to issue proceedings subject to the review of a judge, of course, to do things in the United States. Frankly, he can do some things in the United States he cannot even do in Brazil.
And even applying the Brazilian law.
And even applying Brazilian law. We're suing, in another case we work with them, we're bringing a claim against a bank that Rodrigo mentioned that facilitated the assistance of laundering money through Miami. We're suing that bank, and we're suing them under Brazilian law because our procedure allows you to sue under either U.S. law or Brazilian law. So you can bring your law to the United States and say, this was a violation of my indigenous law. And this was a fraudulent transfer under Russian law or whatever other law is applicable, and use that proceeding, use that law in the United States. But I think the most powerful thing is, if you're the trustee of a company, you are the company. So you walk into Miami and say to the law firm that's representing the company, I'm the company. I own the legal privilege So give me all your records. You go to the accountant that was doing their work in the United States and say, give me all your records. They don't have a choice. They have to give it to you because you are the company. The banks have to give you all the information in the bank account that was owned by the company. They have to give you the account opening documents, the actual statements, brokerage accounts. All of that information now is available to you because you are the company. You stand in the shoes of the company. So you have a lot of power you can unleash into the United States, and you can do the same thing in other countries that have the model law. The United Kingdom, for example, has adopted the model law. Canada has the model law. And other countries, literally the list is growing month by month of countries, and I strongly recommend that, while it's not required, I strongly recommend that Russia adopt the model law. It's not required as a condition of getting relief in the United States that your country be a member or be a signatory, because obviously Brazil is not, but it's helpful. It's easy to say to the judge, we have reciprocity, it's a nice thing. So I think that the real message from the second half of this panel is that when you have this deliberate bankruptcy, when you have this deliberate taking of assets out of the company, and I apologize to the translators for talking too fast too. You'll hear them laugh in a minute, but I always do this. You have a very, very powerful tool that you can use to bring the assets back in and get the creditors paid. It's a very, very, very effective tool.
Yeah, I just want to add that one thing is that when you start this kind of work, you know where to begin, but you never know where it's going to end. And one of the situations that we face together, we got some bank records, a lot of years of bank records, and there is a lot of payments, millions, hundreds, thousands, and everything. And then there was just one transfer that catch your attention. That was a small transfer, $1,200. And why this transaction caught his attention? Because it's the amount used to pay to incorporate an entity offshore. And that was the lead that we took to break in the case and fight the whole new structure of the fraudsters. So it's a lot of info, it's a lot of detail as well.
I will say this, it takes trust from the judges. It takes a strong judge. It takes trust from the judges, both the judges in the foreign country and also the judges that are in the United States. In fact, on some of these cases, the judges actually speak to each other. They're encouraged under the protocols to talk to each other, and because what will happen is when the debtor, I almost said the bad guy, but they're not all debtors are bad guys, so we have to be careful. But when the debtor gets wind of this and finds out that you've got this proceeding, they run back to the home country and they start complaining and saying this is unfair and they're taking advantage of me and they're doing all kinds of bad things. And so the judge in Brazil or the judge in Russia can pick up the phone and call the U.S. judge and have a protocol and have a discussion with them about this situation. And it's happened. And it's encouraged by the act to have this dialogue between the judges, to not allow the debtor to go in and start telling two stories in two places.
Right.
And the judges can say, no, I heard from the judge directly. I know exactly what's happening. I don't want to hear from you anymore. I know you can't, basically they're lying to the judge in the home country. So it is a very, very powerful weapon that frankly, I could tell you the U.S. judges that I've been on panels with are very open to having that dialogue with their counterparts in foreign countries. They see it as part of the shrinking world we live in. As it gets smaller and smaller, it's very important that we have these kinds of conferences so that our judges can talk to each other. More importantly than anything else, that our judges talk to each other and develop relationships and rapport so that they can have this kind of dialogue.
Ed, this is my last intervention. But every time you talk, I remember something that I think is important to share the experience is that we have in our office 4 cases, huge cases, is already, the secrecy is gone. So in these 4 cases, when we collect the documents, the object evidence offshore and bring it to the file, the fraudster, they don't know how to defend because they cannot defend the document that he signed, the email that he sent. So what he does is he attack us on the procedure. Oh, you breached the due process of law. So that's their defense. And there is a little side effect, which is sometimes they attack us personally. Just before coming here to Russia, Ed, I received my 4th subpoena to go to the chief police department to explain some activity that the people that I'm investigating file formal complaints against my office and stuff like this. But it's something that is bearable, but they don't have defense.
And as Rodrigo knows, in the same case, they filed a motion to disqualify my law firm for improper tactics, which the judge dismissed. And just before I left, they filed 4 Rule 11 motions against us for the. Now, Rule 11 is saying that we brought an improper claim or a claim that's not founded. So we have 4 Rule 11 motions pending against myself personally, my law firm, and my client that were just filed days before I left. So I don't have any doubt that those will go the same way the motion to disqualify went. But this is an attempt to please their client, to say they're doing everything they can and they're throwing everything into the fight. But most of our judges, frankly, don't look favorably on that kind of stuff. They see it as a personal attack rather than dealing with the merits of the claim. And the merits of the claim are such that it's hard for them to respond. I always feel good when they attack on the procedure. It means they're conceding the merits. They know the merits are bad for them, and they're fighting on procedure alone. So that's usually for us a good sign.
Коллеги, сейчас у нас стадия вопросов, и у кого накопились вопросы.
We have time for questions. Maybe legal practitioners, maybe bankers. Konstantin Anatolievich, well, the topic of today's panel is about the tools of preventing deliberate bankruptcy. And one of those tools is to inform the bank of the money being written off the debtor's account. To your opinion, is there a chance or a possibility or a necessity to implement a procedure when the bank should inform state organs, state bodies, that their client starts to write off money from his account? You can see mass write-offs. You can only see if you monitor their payments on a daily basis. Inform state bodies for what? Well, I see someone writing off his money. What do I do it for? Do I need, law enforcement officers to come to my bank? No, it's just for a checkup. I mean, there's no threat, live threat. And if someone, who will do the audit? We have state bodies responsible for monitoring financial activities. It's Ministry of Economic Development, but the controlling function is not performed by this ministry. They should be performing it, but they're not. But our legislators have introduced the body. We've heard all the speakers, and I'm grateful to Vladimir Lvovich and to Davis Edward and other colleagues. We got it well. We know that deliberate bankruptcy is bad, but so far we can only see the consequences of deliberate bankruptcy. How can we prevent it? I couldn't see the means to prevent deliberate bankruptcy of a certain debtor. That's why I'm asking, can we actually do it? Or we can't find this deliberate bankruptcy. What should be our conclusion? Well, your conclusion should be the one of your own and the deep one. I grew up in an Asian country. Let's start with something positive. I will compare two impossible things. One impossible thing is you should think of something, and the other thing is whether I have a right. If you would think of some way out, I would award you with a Nobel Prize for economy. If we could find out some preventive measures, we wouldn't have bankruptcy at all. Can you imagine a country without a single deliberate bankruptcy? 15 years ago, I've been to the Ministry of Economic Development when our state enterprises were reporting about their activities in those huge corridors in Moscow, and you had these reports filed, piled up files with reports. I came a week later and I asked them, what are you doing? And they said they were studying them, and there was not a single report left. I don't know if they ever, opened any of these reports. They were thrown away. Believe me, if we have too many claims, check this or that, I don't think they will be all reviewed in time. So I'm pessimistic about it. It's not about law and application of certain measures. We're talking about economic solvency. Do we have any preconditions for that? I don't think we have some, magic tools, magic means to provide for it. Well, we can fight the consequences, though.
Thanks a lot. You helped me because I was gonna say something bad from the start. Now, honestly, and for a long time, I don't believe that problems can be resolved by creating more government agencies. Unfortunately, this has become, how can I say this in a polite way, because we're in public? Well, we're sick and tired. I mean, you all know what it ends up with. I mean, I won't even remind you how many bureaucrats, how many officials we have in Russia today compared with Soviet Russia. It's not because I like the USSR more than modern Russia, but I like comparing things. When special people, dedicated people with dedicated functions emerge, then they start nailing their pencils and in this particular situation, something has become happening. And when someone comes and audits it, I mean, I'm an advocate of the simple model. Let someone come who's got the clear delegated authority. And auditors, it's not just about relationship between government and society. It's in business as well. I mean, the amount of administrative burden when you have regulators, auditors in numbers, and I can see no particular result, no benefit from it. If I'm wrong, I'm ready to apologize as many times as I got to, but I don't believe in that. We have someone who wants to answer that question.
Could not hope to answer the question in any context that would deal with Russian law. Philosophically, our system operates differently. It's a self-actualizing system where the lawyers are the ones doing it, and government involvement is very minimal, kind of like an umpire or a referee in a soccer game where they're calling penalties, but the players are playing the game. And in insolvency, it's one of the areas where we do have government involvement. In each case, there's a U.S. trustee, part of the United States government, the Department of Justice, who oversees indirectly cases. We have a judge who is appointed to oversee each case. And the judges in bankruptcy court are quite active. They're very active. They control their docket. They bring the lawyers in and ask them questions, and they move the case along because it's about getting the assets out. But I would say the answer to the question is, you can't really prevent. When Alexey and Vasily told me about the topic, preventing deliberate bankruptcy, I was scratching my head wondering, how do you prevent someone from exercising a legal right? They have a legal right. Now, they can't exercise it in an illegal or improper way. They can't lie. They can't commit fraud, because fraud debts that are proven to be fraud debts are non-dischargeable, so you don't get to walk away from that debt. That debt follows you around for the rest of your life. But if you're a bank, and I've spent 27 years representing banks, the best way to prevent bankruptcy is to armor yourself with the best collateral. Over-collateralize yourself. If you make an unsecured loan on the basis of a handshake in a relationship, expect to lose all of that money. You're going to lose it. There's a good chance you're going to lose it. Collateralize your loans. We represent banks, and banks come to us, and I will say this is in direct opposition to my own economic interest, because we work a lot for banks in these situations. It's amazing how many loans don't get documented properly. Obviously, our entire bankruptcy section of our firm would be out of business. And unfortunately, banks allow emotions and relationships and other companies that make loans to get in the way of making good business decisions, because they're excited to get married, and they're not contemplating the divorce when they get married, of course, because that's unseemly, and you don't want to be talking to your new wife or your new borrower about bad things that could happen in the relationship. But bad things do happen in a relationship, and so you have to be planning for that right from the beginning, especially in an economic setting. So in my advice, my conclusion, if you would be to try to make sure that your clients, and if you're a bank, your institution collateralizes itself sufficiently so that you don't have to worry about bankruptcy. It's irrelevant. In our U.S. bankruptcy system, the secured creditor is king. They're the king. They pretty much are paid everything, with some exceptions about interest and other things that occurs post-petition, and default interest. They might not get default interest, but they're going to get their debt paid as long as they have the collateral. And they usually can go right into the bankruptcy and say, thank you, judge, I'm taking my collateral, with the judge's permission, of course, and they move off, and it's done very quickly and very cleanly. So I would say there's an easy answer. Make sure you're collateralized.
Just a second. I just wanted to make this very clear, to give you an example. In April, the forum, remember who was there, who attended? I'm not sure whether we had that session where we discussed it with production people and operations, and someone who works either in construction or in road construction, and to a great astonishment of mine, I heard that the government is now working on a special banking service. That is, banks will have to be responsible for checking the work that is done in road construction before the relevant payments are made. I mean, if my understanding is correct, and God forbid, but if that is introduced, because this is already in business, we're all adults here. If we cannot fight corruption in road construction, then, I mean, making this a responsibility of the banks, you know what will happen. State banks will do it, state-owned banks. Other banks won't. Because, of course, this is not a banking activity to go and check how much asphalt is laid on the ground. I mean, and I hope my understanding is wrong, but I think I heard it right. So this is what I'm talking about, you know. This is, instead of addressing the main problem, we're creating new administrative add-ons on top of it, with well-paid people, and it happens, as you know what they said, we wanted the best, but it turned out you know the rest. This was discussed a lot by the speakers, and maybe to summarize the replies, this is mostly the problem of the creditor themselves, because legal mechanisms will not provide a remedy, because you got to understand what's the business, who are the suppliers, who are the customers, and there's a company who does road construction. They're top in bankruptcy because they leave the market through bankruptcy, then they come back adding one or plus to their name and continue doing the same, because that's how their business works. Due to our system of state orders, they are unable to get any profitability, so they abuse this right. Alex, let me ask you, St. Petersburg, are you the only one in St. Petersburg who knows that? It's the entire city who knows it. That's what I'm talking about, because this is a secret that everybody knows, and everybody understands how it works, but we still continue doing the same thing day after day, fighting premeditated bankruptcies, trying to improve the existing system instead of, it's about a devaluation of relations. And because everybody knows in every big city who started a major bankruptcy, who ended it up, and who can re-emerged after the bankruptcy. Maybe someone else has a question?
My name is William Hare. I'm from the BVI in Cayman Islands. Can I first of all congratulate the panel and thank them for an excellent talk. Just very briefly on the last point, you've been talking about what in English law jurisdictions we call phoenix companies, where the phoenix rises from the ashes of the burnt business. And there are very specific laws, statutory laws in England to deal with director abuse in those circumstances, which you might want to look at: fraudulent trading, avoidance actions in relation to the previous entity. Unfortunately, you've also got a theme in Western countries of rehabilitation of companies, and that allows for things like in England the pre-pack administration orders and so on, which have certain features of what you've been describing in quite pejorative terms. So it's a question of striking a balance. I was extremely interested in what Ed has had to say about the US remedies in particular and his Brazilian colleagues. We deal a lot with Russian-related entities that are held through BVI holding companies. In those circumstances, I don't think it's sufficient to say you should hold full collateral for your loan, because quite often the company which owes you a debt, or which may owe you a debt, has no contractual relationship with you at all. So the Russian creditor, for example, or any creditor, will be looking through a series of transactions. It may be, as our Brazilian colleagues have described, where there are offshore entities which hold assets which in truth are owed to an onshore creditor or a group of creditors. And the question that people want to know, that creditors in particular want to know, is how they can make those assets available to pay the creditors. And so it's not a question of taking security, because those companies have never had a contractual relationship. They just have bank accounts, and the bank accounts usually aren't in the same jurisdiction. And as you've heard with the Costa Rica entities, the Panama, Switzerland, when you use a multiplicity of jurisdictions, you can make life very difficult for creditors. But persistent creditors, advised by firms like Ed's, can usually find, if there is a way, they can usually find a way through. And Russians, Ed is absolutely right, they must not give up just because the money has gone outside Russia, or it's held by a company in Cyprus or BVI or Nevis or Belize, or it's a trustee. Don't give up, get advice. It's key. I don't want to go on. I just want to make one or two observations, if I may, about things that were regularly asked, which is, what's the difference between a creditor remedy, like a receivership, and an insolvency remedy, like a liquidation? And there you really see the advantages of the insolvency remedy, because the liquidator, for example, Ed has said the liquidator is the company. He is the company. He stands in the company's shoes. But he also has additional powers that are unique to him as liquidator. He can examine directors. He can bring avoidance claims. So if you're bringing an avoidance claim for a preference or an undervalued transaction, there's no set-off against the liquidator, whereas there might be if it was in the name of the company. So these are very strong remedies, but the most important one, which is relevant to all of us who practice insolvency law, is the ability to get cross-border recognition. So if you're a liquidator in the BVI, you can go to a foreign country where there's a bank. You can go to the US and ask for Chapter 15 recognition, or you can just use the US courts sometimes without even getting recognition. Ed's mentioned the 1782 remedy. For Russian entities where there are BVI debtors or BVI companies that are involved in, that are holding assets that should be made available to Russian creditors, one very interesting feature is that a lot of the activity is dollar denominated. So whilst there may be no US involvement, and quite often is no US involvement in what may be a Russia-Russia transaction or a Russian scenario held through Cyprus and BVI, we quite often see, the bank transactions are done in dollars. They have to clear through 6 or 7 New York banks. If you can see the bank wires going out, you can get 1782 discovery, you can subpoena banks in New York. I'm not an American lawyer, but Ed will confirm this. You can subpoena banks in the US to see which foreign entities are receiving money, where the money is going, if they are dollar wires. If they're euro wires, well, you can't help that. If they're dollar wires, you will see it going through the US, and the banks and the law firms in the US can get discovery against those banks. They can serve subpoenas. You can get information relating to offshore entities. If you put a liquidator into a BVI company, he can get the books and records of that company. The company's got an obligation to keep financial records. You can examine directors, you can examine nominees in Cyprus saying, well, I want to see the emails where you're getting your instructions from. I've said too much.
If I can just pick up on one thing. When I get a loan file from a bank, the first thing I look at are the collateral documents. How good are they? Because no matter if the company's Cyprus or BVI, the collateral should be in your home country. It should be where you can go touch it. And the second thing I look at are the call reports, where the banker puts in his or her file the fact that they went out and met with the client. Now, invariably, those call reports say, had dinner with client, talked about business, looked at the balance sheet. That's not understanding the collateral. You need to put the hard hat on, you need to put the boots on, you need to go out on the site and understand your client's business. Once you understand that business, you can look at it and say, oh my God, we have collateral that's not even here. Or we have a very, very scary position right now because we're taking an interest in certain kind of collateral, and that collateral is liquid and it's moving through the company. You have to really get, I think banks, when they make mistakes, make it because they don't really understand their client's business. Once they get into the business, once they go out there and kick the tires, as we say in America, then you really can understand, and you really shouldn't be losing money on loans at that point. It's very difficult to lose money on loans if you're adequately collateralized, assuming that you're not taking an investment risk or some other kind of risk. And banks are free to do with what they want. If they want to take an investment risk on an unsecured basis and for a very, very high return, then they have to take the risk that goes with that reward. But generally speaking, I think from preventing bankruptcy, the best way to do it is to give them no reason to go to bankruptcy.
Good afternoon. I'm an American practitioner. I wanted to point out one resource that's out there in regard to the question of what can be accomplished. What's the way to prevent this? UNCITRAL, in addition to the model law, has worked on a number of other areas. They developed a legislative guide on how to reorganize companies. They've developed a model law. They've developed a work on protocols. But recently, they just finished a work and published it in regard to the duties and obligations and best practices regarding directors. So there's a lot of commentary, there's recommendations, it goes over details. We had over 80 states, 80 countries that jointly worked together on this project, and it was approved by the United Nations, by the General Assembly. And you can go online at www.uncitral.org and see that. But It doesn't go into specific penalties, but it gives you excellent background. It's a good basis for legislators to develop laws to help address issues and to create penalties where people abuse and violate the process.
У вас вопрос, да?
Уважаемые коллеги,
You have a question? Dear colleagues, I'd like to thank you for some interesting presentations. As a practitioner, a liquidator, it's interesting for me to hear some things here. A question to Davis, Mr. Davis. The question is this. As far as I know, some foreign jurisdictions, the liquidator or insolvency administrator, is that the right term, is a government official, someone working for the government, the state. So what do you think? This practice, is it possible in the Russian Federation, or is it undesirable? Because we're all adults, as it was said here, and this insolvency manager is not totally independent. And I had a bankruptcy some five years ago, and was difficult, impossible to speed it up. So should we have some time limits? Because we have some timing in the civil code, and the situation is this, that this time limit is difficult to observe. Can I ask you, why do you need that, this government? Now, in the UK, there's this practice, so it's interesting for me to hear what foreign colleagues can say, whether this is feasible for Russia.
In most of the countries we operate, in fact, all of them, I've never run across a situation where the trustee or liquidator, whatever you call them, custodian, there are different names in different countries and different levels in different countries, are government employees. They are appointed by a court, and in the English system, unlike the American, it's mostly accountants who are appointed. In the American system, it's about a 50-50 split between accountants and lawyers. And in the civil law countries that I deal with in Latin America, it's usually an accountant who's appointed, but not a government official. I agree with you that time limits are important, but sometimes no matter what we do, the wheels of justice grind slowly. So that is, but if you're fully collateralized, sometimes you're just waiting to get your collateral, and hopefully the value of your collateral doesn't go down. You have to be careful what kind of collateral you take. I had a client who took racehorses as collateral. They're the worst kind of collateral because they eat every day, and they need medicine, and they die, and you can't, it's very dangerous to take that kind of collateral. But I'm being, it's a little silly on purpose, but you know, typical collateral that you would take, a building or big machinery, that's usually a very safe bet. But you can feel comfortable that certainly in the Western Hemisphere and in most of the places I've dealt with in Europe, it's not a government employee.
It's not about the time limits. It's not what we need. Of course, sometimes time is dragged on, but it's like, legally speaking or professionally, it's like shooting a gun into your own leg. You remember this old Russian anecdote that, "Father, I finished that case that you were working on for 20 years. And father said, "Come on, what have you done?" So you have to have a clear definition of two things. This is first level priority. There's of course second and third level, but one of them is, what's important for me is that the bankruptcy procedure must be, in addition to everything else, provide a return of assets into normal civil circulation, reasonable, correct, and so on and so forth, with all the attributes necessary. So this game of playing time limits is working against us. The process at a certain stage, because a process for the sake of the process, when everybody's understood, there's no asset behind. And then getting back to the example of our moderator with the road construction 1, road construction 2, and people is already building their tomorrow's happiness, while in the first one the procedures are going on that no one needs. There's no economical essence there, no positive role in terms of having order in the economy. It's a nonsense, but it continues and drags on, and professionally that's good. And I will tell you over the break how I asked the question many years ago to a colleague, why partner rates are based on hours, the hour rates, why the lawyers work by the hour, you know, why that's the best for the client. So, you know, this doesn't benefit the economy at all. This is not a legal question, because bankruptcy is not just a legal matter.
Just would like to add that if you have a lawyer work on the case as in a contingency fee, you get the job done very quickly, as soon as possible. And in Brazil, it's not an official from government that runs the bankruptcy. It is a well-known lawyer, a well-known, accountable, honorable person, and the judge has the room to pay this professional up to 5% of the assets recovered in the bankruptcy. So the way we do in Brazil is the way that even the trustee, he wants to work fast, he wants to sell the assets, to pay the creditors, and get it done, because he's working in a contingency fee as well. So this model is something that works very well in Brazil, and I think that's why we are having a success case in the past 7 years in doing the asset recovery internationally, because they want to get it done, they want to get it done fast.
Вопросы? Question?
Я, можно, тоже добавлю, немножко отвечая на ваш вопрос.
I would like to add to your question regarding the terms or the statute of liability. After 6 months, you have to close up, and you have to do something unusual, to do a trick to prolong this term. So to introduce cutoff terms is basically very bad for bona fide participants. 2 years, this cutoff term is meant to be in the interests of the civil society, and right now in our statutes the terms are much better. If you have something like 2 years, you have to substantiate it, why you want that, not just because you want to pay more money. Coming back to those road constructors 1 and 3, you can stop the insolvency procedure, just stop it. And then we don't know what to do with this legal person that exists, legal entity that exists, but is forbidden. Coming back to the terms, let's look at the regulations that we have regarding the return of the property after insolvency. We can demand the return of the property, but this regulation doesn't work. Nobody knows how to divide it. The Ural Sea Bank, for example, can it return this asset? Does it have to divide it with other creditors? Nobody knows. So these cut-off terms, they can create more problems of that kind. You have to be very sensible about that. A tough judge needs to be in place. Somebody who applies the law very strictly, reacts to lies. But we don't have that kind of culture. There is no responsibility, no criminal responsibility, as opposed to British and American procedures.
I would like to compliment the panel. I think the discussion has been excellent and very informative. some of the questions and the title of the program would suggest that fictitious bankruptcies or fraudulent bankruptcies, there's an answer to preventing them. And as others have commented, there is no answer, there is no way to prevent entirely and completely false bankruptcies. And Russia has only had a bankruptcy law since 1992. That's only 22 years ago. Other countries have been working and trying to improve their bankruptcy laws for literally a couple of hundred years. In the United States, it's mentioned in the Constitution bankruptcy law. But the first real law that we ever had in the United States was 1898. And we have been working since 1898 to try and develop an effective bankruptcy law that worked for creditors and worked for debtors in order to rescue companies. It's an ongoing process. There is no single answer, there is no single remedy for false bankruptcies, but it's a combination of different tools that have been discussed here, and it takes time to develop them, and it has to be done with sensitivity to Russian legal culture, and that makes it difficult, just like it was difficult for Americans to develop it, or the Canadians, or the Brazilians. So I would suggest that it's not an easy task, and it's not done quickly. To answer the question about what tools could help avoid, two things for me at least come to mind in addition to the good comments already made. And that is, one, transparency. If you require disclosure of financial information, whether it's in the bankruptcy process or whether it's applying for a loan or filing your taxes or whatever, the more transparency, the better to eliminate fraud of all kinds. And the second word that comes to my mind would be sanctions, penalties, serious penalties, to set a standard and set an example for others that if you engage in fraudulent conduct, there can be a very serious penalty that you pay, and it can be both criminal, which we've heard some conversation about, but it can also be civil, where you are penalized financially, or you lose your assets. So I would hope that when the panel or others talk about tools that we use in other countries, they'll be developed, and I think that they will work in Russia the same way they work other countries, but it's just a matter of time and hard work.
Есть еще вопросы у кого-то?
Any other questions? Thank you very much for this very interesting discussion. It was a pleasure. Thank you.